Mr. Speaker, I beg to move that leave be given to bring in a bill to make provision for the effect of an apology in certain legal proceedings and for connected purposes. Let me start by making a declaration that I am an associate of the Chartered Institute of Arbitrators, since the heart of this bill lies within the dispute resolution and dispute prevention system. Let me also start out by saying what this bill does not do. It does not take away any rights that we may have to go to court on any issue. But what it does do is to introduce an element of civility and common sense back into society, in that it allows an apology to be given that is genuinely and sincerely meant without creating a legal liability that could run into millions of pounds. Simply put, an apology which does not create a legal liability will often settle a dispute rather than being seen to take the accused for every penny that they have. It should be the mark of both a mature democratic society and of its dispute resolution system that an apology, whether made publicly or privately, can and should be allowed to be meaningful and helpful rather than simply a necessary yet tokenistic gesture. An apology can truly change atmospheres and the nature of conversations and outcomes. Used appropriately, it can also help avoid a dispute going to court. Equally, it can assist the resolution of a case by changing the approach being taken. The policy driver, therefore, behind this initiative is that apologies can often unlock disputes and lead to settlement without recourse to formal legal action. Since parties may be reluctant to do anything that may be construed as an admission of liability, apologies have to date seemingly been sparse, save in cases of NHS clinical negligence. However, a culture has emerged of people and organisations not wanting to offer an apology in case it is detrimental to their legal position or deemed to be a weakness. With tragic incidents like that of Grenfell Tower and the need to improve multicultural community cohesion, the time has come to extend the current limited legislative provisions. A Fresh Apologies Act would be a clear Westminster statement, as well as a simple legal mechanism to help improve our country's conversations, for it could incentivise disputing parties to make apologies, whether in the direct aftermath of an accident, mistake or other dispute, or further down the line, should the dispute escalate with a view to achieving a more amicable resolution. An NHS publication, Saying Sorry, published in June 2017, reminds of a little-known provision in the Compensation Act, which provides an apology, offer of treatment or other redress shall not of itself amount to an admission of negligence or breach of statutory duty. More significantly, in the same medical context, there is the duty of candour under the Health and Social Act 2008, and more fully described in a leaflet published by Action Against Medical Accidents, endorsed by the Care Quality Commission. Both the Medical General Council and the Nursing and Midwifery Council advise that this means that healthcare professionals must tell the patient when something has gone wrong, apologise to the patient, offer an appropriate remedy or support to put matters right if that is possible, and explain fully to the patient the short and long-term effects of what has happened. So how has such common-sense advice worked in practice? A search during the preparation of this speech found that there was limited empirical research through acknowledgements of the benefits and anecdotal examples of its successes. In fact, the most helpful insight into the successful outcomes of medical apologies comes from an article in the National Law Review, a US professional publication dated the 6th of November 2018. Bearing in mind that the majority of US states have on the one hand apology legislation, but on the other a highly litigious approach to life's adversities from the current president downwards, nonetheless, I quote as follows: "Physicians typically recall with stunning clarity the moment a patient's treatment went wrong. Following an adverse event, physicians often are tormented by competing desires to apologise and instincts to forge ahead without acknowledgement. A patient's decision to file a malpractice action may be triggered by the physician's response to a problem or lack thereof." Apologies may decrease feelings of frustration and anger that drive some plaintiffs to file lawsuits, and a study published in the Journal of Patient Safety and Risk Management found that those engaging in a collaborative communication resolution program experienced a significant decrease in the filing of legal claims, in defence costs, in liability costs, and time required to close cases. Events with medical errors were resolved by apology alone in 43% of the cases involved. Similar programs have cut the number of malpractice lawsuits and yielded dramatic litigation cost savings. Not only do the majority of US states have apology statutes, so do Australia and Canada. Even Hong Kong, whose legislature was the first jurisdiction in Asia to enact apology legislation by the 2017 ordinance, though unable to put its best intentions into effect due to the growing restrictions from mainland China on its governance and judicial systems. Turning closer to home, there is the approach taken by Holyrood with a short yet powerful statement, the Apologies Scotland Act 2016. It contains only 6 clauses, including its commencement and short title. The 2016 Act defines an apology as any statement by or on behalf of a person which indicates that the person is sorry about or regrets an act, omission or outcome, and includes any part of the statement which contains an undertaking to look at the circumstances giving rise to the act, omission or outcome with a view to preventing a recurrence. To constitute an apology within the terms of the Scottish Act, it must include an acknowledgement there has been a bad outcome, an expression of regret, sorrow or sympathy, and a recognition of direct or indirect responsibility. In addition, there may also be an undertaking to review the circumstances of the incident with a view to making improvements or learning lessons. The Act applies to all civil, not criminal, legal proceedings, with some exceptions. And the following considerations are worth noting. Qualifying apologies may be oral or in writing. The core element of an apology as defined in the Act is an indication that the person is sorry about or regrets an act, omission or outcome. Where the statement includes an undertaking to look at the circumstances with a view to preventing a recurrence, that qualifies as part of an apology. An apology does not include statements of fact or admissions of fault, so in any statement that includes both an apology and a statement of fact and or admission of fault, only the apology is inadmissible as evidence of liability. It makes it possible to apologise without fear of prejudicing the person making the apology, or the apology being used to attribute blame in litigation. It applies to all civil proceedings except 4 types of specific actions. It does not apply, as I've said, to criminal proceedings. In a subsequent article written by Scotland's most high-profile mediator, John Sturrock QC explains how this piece of legislation achieved the rare distinction of achieving enthusiastic cross-party support. I quote, "Over 4 years, Margaret Mitchell, a Conservative MSP, has piloted this legislation through the Scottish Parliament with skill and tact. As one member noted, both sides have been pretty consensual in trying to ensure that we end up with something that the Parliament can be genuinely proud of. The essence is that apologies have the great value of acknowledging that something has gone wrong and demonstrating that lessons have been learned. We all know that mistakes happen. This is a sad fact of life, and that they can often have tragic and long-lasting consequences. However, it is how we deal with those mistakes that makes the difference." John Sturrock continues, "It is clear that legislation alone cannot remove social barriers to apologising, but the bill is an important step in changing attitudes to apologies. As my fellow APBG officer, the member for Worley, and I learned and have written about in our recent APBG report, the UK and Singapore as global dispute hubs, best practice lessons, policymakers and institutions in both the UK and Singapore should foster a paradigm shift where disputes are not viewed solely through a legalistic lens, but the pursuit of the ever wider and ever deeper range of dispute resolution options. It also requires thinking about disputes in a way that goes beyond the legal conceptual framework and encompasses in all aspects of commercial relationships. In conclusion, may I commend the Scottish approach to this House a short, focused, yet of profound effect, much like the speech I've just given.
No apologies then. That the honourable member have to leave to bring in the bill. The question is that the honourable member have leave to bring in the bill, or as many of that opinion say aye. Aye. The contrary no. I think the ayes have it. The ayes have it. Who will prepare to bring in the bill?
John Speller, Greg Clark, Chris Grayling, Chris Bryant, Kenny McCaskill, Sir Paul Beresford, Sir Roger Gale, Sir Bob Neal, Heather Wheeler, Sir Geoffrey Donaldson, Rob Butler and myself, sir.
John Howell.
Apologies, Bill.
Second reading what day?
Friday, the 5th of March, 2021.
Friday, the 5th of March, 2021.